Good evening. Thank you for joining us today for Small Business Week. I'm Elisa McCain, the Executive Director of Texas Accountants and Lawyers for the Arts, and welcome to our seminar on obtaining a patent. Today's seminar is generously supported by the United States Patent and Trademark Office and the Texas Bar Foundation, and is being presented as part of Austin's programming for Small Business Week. The City of Austin has put together many educational programs during this week, and you don't have to be in Austin to take advantage of these webinars. You can find more information at Small Biz Austin, that's smallbiz.austin.org. Talus Patent Pro Bono Program serves under-resourced inventors in Texas by providing patent application assistance to financially qualified individuals that have inventions that are ready for a patent application to go to the USPTO. We hope that you find this information useful as you consider applying for a patent. You may find out more information about our Patent Pro Bono program on our website at talaarts.org. It's TALARTS.org. If you're logged onto your personal YouTube channel, you'll be able to ask questions in writing using the chat feature. Our speaker will answer as many questions as possible at intervals throughout the presentation and at the end. I wanted to introduce you to tonight's presenter, Kirby Drake. Since 2002, Kirby Drake of Kirby Drake Law has focused her efforts on helping clients successfully navigate their IP challenges. She thrives on troubleshooting intellectual property issues. She also enjoys being an advisor to clients when they need assistance in identifying, protecting, and leveraging their intellectual property. Kirby has a special focus on the patent process and is a registered patent attorney. Not only does she work with clients to tackle their IP issues, but she's also committed to IP education like this and advocacy through her work with the State Bar and the American Chemical Society. As part of the State Bar of Texas, Kirby served as the chair of the intellectual property section for the 2018 and 2019 bar year. She holds a bachelor's degree in chemistry from Duke University and a JD from Wake Forest University School of Law. She's a member of Talus Patent Pro Bono Advisory Committee and has helped us set up and continue to operate our program. So Kirby, let's get started and learn how to file a patent.
Great, thank you, Elisa. Let's see, let's get the slides up. Okay, so as Elisa said, today we're going to talk about some of the basics of obtaining a patent. And so we're going to cover a whole bunch of different things in the time that we have. Hopefully we'll cover all the things that you have questions about, but as she mentioned, if you do have questions and you'd want to submit them through the chat, we'll take as many of those as we can, or you can contact us later if you have questions that you think about after this presentation. So when we think about patents, we actually start back in the Constitution. So in the Constitution, there is a provision that says that we're to promote the progress of science and useful arts, and that's actually where the patent system was brought into existence way back then. So we start with the Constitution, and we still look at that even today. So looking at this is just an example of actually the old style patent. There's a slightly different cover now than there used to be, but this is what we traditionally look at as the cover of an official patent. And essentially what a patent provides is it gives whoever receives the patent, so a person or entity, whoever came up with the invention or has the invention assigned to them, they have title to the patent, and they're given the right to exclude others from making, using, offering for sale, or selling the invention. So typically we think of a patent as giving the right to exclude as opposed to giving you the right to do certain things, even though you may think about excluding others as a right to do something, but it's not giving you an exclusive right in terms of making or requiring you to make a product, but you can stop others from making it, using it, offering it for sale, or selling it. I didn't mention here on this slide, but there's also an importation restriction as well. So sometimes that can be helpful, particularly if you think that you have competing products out there that might be covered by your patent that are coming in from overseas, perhaps are being made overseas but are being used in the U.S. The U.S. patent will give you that right to stop the importation of those products if they violate your patent. So we're gonna spend most of the time tonight talking specifically about the types of patent applications, the components of a patent application, and then some of the process issues and common pitfalls that people have when they're engaging in patent applications. So typically, and what I think we'll spend most of our time on tonight is a utility patent application. So this is in contrast to a design patent application. So utility is protecting something that has a function. We often think of, perhaps mechanical inventions, or it could be chemical inventions, or electrical, or what we look at a lot of times lately are computer-based inventions. It could be smartphone apps, things like that. And we're looking at what actually is performing a function, is doing something useful, and then of course something that's new. And that's in contrast to a design, which is actually protecting something that's much more ornamental. It's going to be the look of a product, for example. So the most common example that we use when we look at design patents would be, or comparing it to utilities, would be if you're thinking of your smartphone, such as an iPhone. If you look at it, there's lots of things that the iPhone does. You're able to make calls on it. You're able to surf the internet. You're able to text. Use all the different applications on there, and so those are all functions or things that the phone has to be enabled to do. Whereas Apple also has design patent protection on the iPhone, and that would be related to the shape of the iPhone, the way it looks, the curvature of the edges, and things like that. And so it's not so much a matter of the functionality of the iPhone, but the way it looks and how it compares to other products that are out there. So that's kind of a way to try to set apart those two things. Mostly what we're going to talk about here tonight are going to, would be falling into the utility patent application area, but, we can also address some questions or some issues related to design patent applications as we move along. The last category of patent applications that we're really not going to cover tonight, mostly just because they're not very common, are plant patents. And these are typically, you might think of seeds or unique, kind of sequencing of how a particular plant has come into being, and so those get special protection through plant patent applications. And again, those don't happen very often, but if you do think you have an issue with the plant patent application, or you might have some occasion to use that, we can definitely point you in the right direction on that, because there are not that many people that that work in that area, but there definitely are those that can assist you on it. So now we're going to look at the different parts of a patent. And so this is a typical patent cover page, and I've highlighted several different points that are on this page, and we'll blow them up in a little bit more detail. So first, in your top right corner of the patent cover page, you're going to see the patent number, and that's the patent number that is assigned by the U.S. Patent Office when they approve the patent and it actually issues as a patent. And so these numbers are in sequential order. You'll see this one's kind of a looks like it's an older patent because it's in the 6 million range, but now we're up into the 10 million range. So that's where the current patent numbers are being issued out, and they're done in sequential order. So then there's some information that you'll see. This is blown out from the left-hand column, and specifically it's the title of the patent. So in this case, we're looking at a patent for a stool, which is not this is a sample patent. This is not an actual patent that was issued, but it's a good example to look at for kind of understanding the component parts of it. But whenever you do file a patent application, you need to come up with a title for your invention, and it doesn't have to be anything very long or involved or overly descriptive. You see with this one, they identified it as a portable apparatus for sitting. If you could look at it and say it's a stool. If you want it to be, specific as that, if it's a new kind of stool, it might be an improved stool or adjustments to a stool or things like that. And so it's really up to the inventors, perhaps working with their attorney or their patent agent to come up with that title. But there's not a lot of restrictions in terms of how you title your invention. It just has to tie back to what you've actually tried to cover in the patent. You also have to identify the inventors. So these are going to be the people who actually came up with the substantive items of the invention that are being protected in the patent. And so sometimes it could be a single inventor. Sometimes you could have multiple inventors, and it's always important when you're filing a patent application to confirm who those inventors are, to make sure that no one's left off that shouldn't be left off. But at the same time, also to make sure that everyone that is listed as an inventor is actually did contribute to the invention. So most common examples of times where we might question whether everyone should be listed as an inventor is if you're working in a professor's lab at a college or university, and the professor is not actually working on the project. Perhaps he's just providing the facility. He's provided the funding for the research that led to the invention, but the two students that are working in the lab are actually the ones who came up with the invention. In that case, it might not be proper for the professor to be listed as an inventor. It would just be the two students. But we have to look at each situation on a case-by-case basis to determine who those inventors are, and we do that at the time of filing of the application. Also mentioned here, it's not highlighted specifically, but you can have an assignee, and that could be a company perhaps that the inventors work for, or someone who actually is obtaining the rights to the patent. So sometimes the inventors do not retain those rights, particularly if they work for a company or are employed by a university or places like that. Then they may owe their rights over to anything that they have come up with. And so if they've done that, it could be listed as the assignee or the applicant. That company can be listed, but you always have to list inventors regardless whether there's an assignee or not. So we also have on the left-hand column is the filed date, and this is going to be the date when you filed your patent application. So that's going to be listed there, and you always want to make sure that was the date when you actually did file, that they didn't make a mistake on that, because sometimes having that that date is helpful. Confirming that it's correct is helpful, particularly given that the number of years that your patent is potentially in effect for, or the life of the patent is actually calculated from the filed date. So you get 20 years typically from the filed date, subject to payment of the maintenance fees. So you want to make sure that date is the date when you actually did file the application. And then finally, under the patent number on the right-hand column, you see the date of patent, which that's the date that the patent was actually issued. And so it was actually printed in this form. So you'll get an allowance when your patent has been approved by the patent office. And then at some point, a couple weeks after you've paid the issue fee, then the actual grant date or the date of patent will be identified. And that is actually what's listed on the patent. And that's how your maintenance fees are calculated, the dates when they're due, but we'll talk about that a little bit later on. So the second part of a patent application, and so in this case, it would be essentially, a couple of pages into the document itself, when you see the printed out patent, is the specification. And the specification can include, sometimes it could be, in this case, it's 6 columns of text. Sometimes they're much longer. Sometimes they're even shorter, depending on the complexity of the invention. But it contains some different parts, including the background of the invention, a detailed description, and then the claims. So we're going to look at each part of those in a little bit more detail here. So I'll just mention before we jump into those that there are some different requirements that you have for the written description or the specification. Particularly, the Patent Office sets out requirements for how the margins are, the spacing, how you number pages, how you number the paragraphs. We're required to have claims at the end, which we'll talk about. Those claims have to be supported. And then you can also refer to related applications. So if there's more than one application that's pending, then they're all related to each other in some way, you can identify that. So these are all requirements that are written out in the Manual of Patent Examining Procedure that particularly if you're working with a patent attorney or an agent, they will have probably know all these requirements by heart if they've been doing it for a while. But but if you are trying to go at this on your own, you have to make sure that you do meet those requirements, because they will kick it back to you if you'll get your filing date, but they're going to make you make these corrections in order to proceed with the examination. So that's why sometimes it is helpful to have an attorney or an agent work with you to make sure that those things are met from the beginning. So as I mentioned, there's several parts of the patent application, and so in this case, again, going back to the cover page of the patent, I typically consider this part of that written description or specification part, but when the patent issues, it's actually printed on the front, and it's the abstract. And the abstract is, essentially a high-level summary of your invention. You think of it as kind of the thumbnail, or the could be the summary paragraph. If you were writing an essay, or you're looking at the summary on the back of a book of what the book is about. So there's not a lot of requirements about the abstract, except that when you do submit it, it has to be on a separate page. It can only be one paragraph, and the final requirement is that it has to be 150 words or less. And so that's when being able to use the Microsoft word count convention for being able to check the word count is always helpful on that, because they don't really look at the details of it. You can be as narrow or as broad in the abstract as you choose within reason, but they are going to check to make sure that it's 150 words or less. And if it's more than 150 words, they will send it back to you and ask you to reduce the words. So just be aware of that. So another part of the written description or the specification is the background. And you'll typically see this on the first kind of full page of text after the patent cover page, if you're looking at a patent. And what the background section provides for is giving the reader or giving the patent examiner a little bit of information about essentially what is the problem that you're trying to solve. So you're not going into the details of actually how you solve the problem, but in this case, you'll see that the inventors of this of this stool identified that that people want a place to sit. They could rest by lying on the ground. They could have issues in terms of what the ground is looking like, and where they could find some place to sit. And then they may not be able to put that many seats together if you're outdoors. And so that was the problem that this particular patent was trying to solve by introducing the stool that is in the sample. So you're not going into a lot of detail about it, but just enough to kind of set the stage as to what the problem is, so that the reader can understand why you're coming up with this invention and essentially what you're trying to solve. So as I said, there's no specific requirements in the background section. Generally, if you have done a patent search or prior art search, as it's sometimes referred to, you might have a brief description of whatever you've identified in there, but you're not required to do a detailed analysis of the prior art. The only requirement that you have with respect to anything that you've searched or identified that is relevant is that you submit it on what's referred to as an information disclosure statement. But even there, you do not have to characterize or describe or show how it's related or not related to your invention. So I typically don't go into much detail about things, even if we have done a prior art search. I don't put that in the background section. I mostly focus on just generally what have others done and failed to do, what is the problem, and ultimately this is going to help the examiner to search for, what might be the relevant prior art in examining what your patent application is about. So another part of a patent application, and this is this is a very simple simple example here, as we said, but you have to include, in most cases, except for probably if you're talking about, chemical or pharmaceutical type inventions, generally you have at least one drawing that is included as part of a patent application. And sometimes there may be multiple drawings. It depends on how many different things you need to show to, to convey what it is that you're trying to protect. So in this case, we see that there are, in figures 1 and 2, you have 2 different configurations of the stool, one with 3 legs and one with 4 legs. So those are different embodiments, or examples of how the stool could be configured. And then in figure 3, we again see the 3-legged stool, but we see that essentially a back has been added to the stool. And so that's giving another example of a way that the stool may be presented. So all of these things would then be described as part of the written description in the patent application. So as I said, they're highly recommended to have drawings. I think in most cases, particularly if you're doing anything that's mechanical, the patent office is generally going to require them because they think that you need to be able to visually see it as well as have it described in words. You're not actually putting things at actual size or scale. You can use scaling to so that things can fit onto the page. But there are a lot of rules as to the size and the type of paper, the margins, the font size, things like that. Again, if you're working with a patent attorney or agent, they can help you to kind of decipher all those rules because we use them every day. But a lot of patent attorneys or agents also utilize a draftsperson who has some familiarity with the patent office rules. And so, so that sometimes helps, even though an extra cost would be involved in hiring a draftsperson to work on preparation of the drawings. They do know all of these requirements, and they can take what you might have as sketches or hand drawings or really rough drawings or things that you've done in PowerPoint or you've done in a drawing program or things like that, and they can make sure that they meet all of the patent office requirements and don't have issues that would lead to a rejection of your application. Finally, the drawings are generally in black and white. There's not an absolute rule against putting color into them, but sometimes you will, if the color is not absolutely necessary to the to depicting the invention, then generally it's important to try to keep things in black and white as much as possible, because otherwise the patent office may require you to submit replacement drawings to get it into black and white, because that's just easier for them from a printing standpoint. So there's also a section, and this is going back to the written part of the application, is that if you're going to use drawings and include drawings as part of the application, then the patent office does require that you provide a brief description of those drawings. And that's a very high level kind of essentially a table, almost like a table of what are the drawings showing. So as I mentioned here, it could be that you're showing different views of the invention. So you might refer to something as this is a schematic view, or this is a top view, or this is a cross-sectional view. In the case of the drawings that we looked at with respect to this stool, it could be as simple as, here is a view of a three-legged stool, and here is a view of a four-legged stool, and here is a view of a three-legged stool with a back. And so, so it doesn't have to be really complicated, but it's basically orienting the reader to, to understand, if it's not apparent on its face, what the drawings actually are demonstrating. So now we're moving into kind of the I'd say the meat of the patent application, and this is the detailed description. So the detailed description is essentially describing everything about your invention. And so some of the description may be with reference to the drawings that we just discussed, and you'll see in this part here that that it's talking about the different the different legs of the stool, and they're referred to as the elongate members, and that they're joined to the planar surface, which would be the seat of it. And each of the, in this case, each of the parts that were identified in the drawing or the figure have been labeled with numbers to make it so that somebody could read this description, look at the drawing and understand which parts are being referenced. So it's not required to have all of the numbering in there, throughout. There may be some parts of your description where you're not actually referring to the figures specifically. And so, but for the parts where you are referring to the figures, if you can give the reader some understanding of what is, what is being referred to, then that's often a very helpful way to do it. So kind of the high level requirements when it comes to the detailed description is that if you have different embodiments or different examples of the invention, then you have to describe each one of those examples, and it may be methods. So if there's a particular method or way that that the product is getting put together or it's manufactured that's really unique, then you may want to describe that. You need to be specific, and you need to describe the invention fully. So this is the one part that, particularly once you file the more formal utility patent application, that you can't really go back and add description to it later. So you want to make sure that all of the things that you think are relevant to understanding the invention and how it works and how it might work are all described in there. As I mentioned, if you are using drawings, then you should include the references to numbers in the drawings. And then finally, you can use examples. So this may not be applicable to all inventions, but for example, if you've done different tests or different lab trials or things like that with your invention, then you can also include those results, as they might be relevant to understanding why the invention is important. So now we're getting to the part that is probably the most complicated part of a patent or a patent application, and I would say certainly the part that is probably most helpful if you are working with a patent attorney or agent, if you can, to have them assist you with it, because the claims are essentially what we refer to as defining the boundaries or the kind of the property lines around your invention. So you can describe a whole bunch of things. You could put a bunch of things into your drawings, describe things in your detailed description, so on. And some of that information may be background information. Some of that information may not be relevant to what specifically you've invented or what the patent office has determined that you invented when comparing it to prior patents or patent applications that are out there. And so the claims have to be written in a very specific form. You see on this this blowout, this is for a wristwatch system, and so there's, in this case, there are 6 different components of the wristwatch system. And each of them are called out in a specific way using the system is identified with as claim number 1, and these are the components under it, and they have to be written in a particular format. And this is essentially what the patent examiner is looking at and what they're going to do their search on to determine whether there's anything that would cause you to not be able to get a patent on this particular invention. And as I mentioned before, while when you do put the description in, when it's actually submitted to the patent office, you can't really go back and change that. So you want to make sure that it's fully described and that you're not leaving things out. But in contrast, the claims section, this is the part of the patent application where, we look at it as, it's the part that can change in a patent application depending on what the examiner identifies as, as relevant patents or patent applications or other references that might affect the boundaries of your invention. And so you can make changes to these claims as long as there is support in your drawings or in the written description for making that change. So we sometimes will start with claims that perhaps are, we want to start them as broad as possible, and then depending on what the patent examiner finds, then we may end up narrowing that as long as we have support for those changes in the patent application. So we'll go into that a little bit more later on, but kind of the key things to remember here, that it's defining the boundaries of the invention, can change over the course of the examination process. You want to be sure to be particularly pointing out and distinctly claiming the subject matter that you believe to be the invention. And then ultimately the key point that will be relevant, kind of all the way through the examination process as well, is any terms or phrases that you use in the claims have to be supported by the written description or the specification so that somebody can understand it. So either the patent examiner or the public later reading your patent, could go and look up those terms or phrases and understand what they mean by reading your patent. This is kind of the general rule that we look at when it comes to the claims, but the helpful thing to think about sometimes is that you're not necessarily required to use the terminology that you think everybody else would necessarily use within the field. If you have a particular term or phrase that you use to describe a component of your invention, it doesn't have to be something that comes directly out of a technical dictionary or a handbook or textbook or things like that. You are allowed as the inventor to essentially come up with the names for the components, as long as your drawings or your description are identifying what you mean by that term. So, you may, in thinking about that stool example, they referred to, what we might consider to be the legs of the stool. They referred to them as elongate members. And that's perfectly fine as long as, if somebody's looking at those drawings and looking at how those components are described, they could understand which part of the stool is being referenced. And so you might decide to just refer to them as legs and show that in the drawings, but another person may refer to them in another way, and there's nothing wrong with that. So long as you've fully found the support in the written description for it. So I've kind of mentioned this I guess indirectly, previously, but we'll go into this because I think this is a question we get a lot about utility patent applications, or questions about, well, do I do a provisional or a non-provisional, and what does that mean? So there's these are terms that are only relevant to utility patent applications. There's not different types of design patent applications, for example, and there are not different types of plant patent applications. So utility are the only ones where there would be provisionals and non-provisionals. A provisional application is generally considered to be a placeholder application because it's something that doesn't have to be as formal. There's not as many requirements that the patent office puts in place for it. You don't have to have the claims written out, which is sometimes very helpful, especially if you're trying to get something on file sooner rather than later. And ultimately, the provisional it gives you up to 1 year after the filing date for you to convert it over to the non-provisional, which sometimes can be referred to as a regular utility application. Sometimes I refer to it as more of the formal application, because the provisional may be considered less formal or informal. And so the non-provisional, you're going to have to make sure that you have the claims written out at that point. If you are including drawings, you have to make sure that they are meeting all of those drawing requirements that we talked about. But those are things that you don't have to be as concerned about if you do a provisional. So there's a lot of different reasons why someone might choose to do a provisional as opposed to just going directly to a non-provisional. Sometimes it's that you're about to show the product to somebody, and you want to make sure that your patent rights have been protected or in the process of being protected, and so you need to do something quickly. Sometimes you want to buy that extra time with that up to 1 year to file the non-provisional to actually test the market and figure out if anybody is actually interested in the product that you're trying to get patented. Or, can you get investors that might support the product and things like that. And so it might help you to make a decision about how far you're going to go with that invention. Because there are some inventors that may test the market over the course of that 1 year, determine that what they thought that they had a market for, they no longer have, and then elect not to pursue the non-provisional. But it also could give you time to kind of build up the momentum and perhaps get the funds together to be able to go into the non-provisional and do that very effectively. So we're going to look at these are mostly the requirements when it comes to a utility, and I'll say, this is the regular utility. So this would be if you're actually going to the more formal application. Although some of these things are still required when you come to provisional, and I'll point them out as we go along. So we're going to talk about a couple of different things here. The application data sheet, the inventor oath or declaration, of course, the filing fees, which is always a big question when it comes to these things. What is it going to cost? What do I have to pay to the patent office? You could have a power of attorney. And then, of course, the last two are things we've already talked about in terms of the written description, at least one claim, and then drawings if they're applicable. So looking first at the application data sheet, the nice part with most of these forms, and I've pointed them out on the slides here, is that a lot of these forms are available on the U.S. Patent Office website. And if you do obtain a USPTO account, which is free to obtain, you can actually do a lot of these as fillable forms, which kind of simplify the process and make it where you don't have to scan things in later, and so it can kind of streamline the process. But the application data sheet typically is being used to identify the inventors. Provide some application information. So the title, if you've got, if you filed a provisional before, you may be able to maybe putting a claim to priority or the domestic benefit information. Could be, in some cases, you could have foreign priority information if the invention started overseas. And then applicant information could be in case of, if it is a company, then, if the company's been involved, you could identify the company there if the company is going to own the invention, or if somebody else is going to own the invention other than the inventors, then they can be identified on the application data sheet. The second form, and again available on the Patent Office website, is the oath or declaration, and this is a form that each inventor is required to sign, and I do recommend using the form off of the USPTO website to make sure that you're meeting the requirements, and it's in writing, and each inventor has to sign it. And what I've listed here are the statements that the inventor is attesting to when they sign the oath or declaration, and these are statements that are actually included on the form that the U.S. Patent Office provides. But essentially, you're confirming, if you're the inventor, that you agreed that the application should be made, and then you also believe yourself to be an original inventor of the invention that's described in the application. And this is a form that, especially if you're filing a non-provisional, because it's not required with a provisional, But if you are filing a non-provisional, it's in your best interest to make sure that you submit this oath or declaration at the time that that you file the application, because otherwise you do get charged a late fee for submitting it after the filing. So it's about I believe, for a small entity, it's about $80, but you might as well just save yourself that money if you can get it signed and submitted along with the application. So the fees, this is kind of just the high level information, but for a utility patent application or non-provisional, they do charge a lot of different fees that do change over time. But those are fees. The fees that you're paying when you initially file the application are fees for filing, searching, and examining the application. Once the application is approved, then you do pay a fee for having the patent issue. If you did have to go through an appeal process, which we're not really covering in much detail here today, there is a fee for doing an appeal. And then once your patent is issued, then there are periodic maintenance fees that have to be paid to keep the patent alive through the life of the patent. It's always cheaper to file electronically. They're really discouraging paper filings these days. And then there are fee reductions that you can qualify for if you're a small entity, which is usually under 500 employees. Then your fees can be reduced by 50%. And then if you are a micro entity, which is determined based on a gross income formula, or if you're an institution of higher education, then your fees can actually be reduced by 75%. And that can be a great benefit especially for individuals or people kind of starting out and needing a little bit of break on those fees. So I've listed a couple of the fees here. These are listed for the micro entities. So if you think about it, like with the basic filing fee, search fee, and examination fee, that's gonna run you about, I guess, let's see, be about $455 if you're a micro entity, and if you're a small entity, then it runs about $830, and then would be twice that if you were a large entity. So those are kind of the fees that you need to have in mind when you're actually starting to do the filing. There are excess claim fees, so you're allowed 3 independent claims and 20 total claims without having to pay any excess fees. So I generally recommend staying within that. That's usually more than enough claims to get your invention across, and it also saves you those extra fees. And then the issue fee is currently, for a micro entity, is $300, be $600 for a small entity, and that's paid within 3 months after the patent is allowed. So I mentioned here there is a power of attorney form, and you can use the one off the USPTO website. But this is if you're going to have a patent attorney or an agent act on your behalf. So this would essentially give them the power to be able to talk to the patent office, file things on your behalf, and essentially move through the process. So this may not be applicable in all cases, but if you are working with the patent attorney or agent, they will ask you to execute that document to be able to move forward. So the nice part about the electronic filing when it comes to patent applications at the U.S. Patent Office is that you get an immediate acknowledgement of filing if you file electronically. And so on the same, basically the same day that you do the filing, you'll have your filing date confirmed, and you'll also get your application number assigned. So, so technically you can say that you're patent pending essentially as of the time that it's filed electronically. So I, definitely recommend that, you do get a more formal confirmation, within a week or two after you do the filing. But if it's important for you to have confirmation of that application number right away, then you have it without having to wait for the patent office to respond. As I mentioned before, with provisionals, the key is, to convert it over to the formal non-provisional application within 12 months. Otherwise, you can't claim priority to that filing date. So, whatever benefits you get from the provisional and having that early date, if you don't convert within 12 months, then you've you've lost that benefit. So you want to make sure about that. And if you are working with an attorney or an agent, they will generally, send you reminders as you're getting closer to that deadline to make sure that you have enough time to make that conversion. The other consideration is, in some cases, foreign filing is desired, and if you do want that, you have to file within 12 months of your original filing date. So let's say you wanted to try to have coverage in Canada, then you file your application today, then here in the US, then you have up to 12 months from today to also file an application in Canada that would get the benefit of your US filing date. But you have to do it within the 12 months. Otherwise, you will have lost that ability to file and claim priority. So I'll mention a couple of things about the examination process. There's many things that we could talk about here, but we'll just kind of high level discuss it today. Most likely once you file your application, some period of time later, depending on the workload of the patent examiner that's assigned to your case, you'll get a communication from the patent examiner that's evaluating the patentability of the invention. And I say on here, it may include one or more rejections. Typically, in most cases, we do see at least one rejection based on patents or publications that are believed to predate the invention or are considered to be prior art. And so this is not something that you should be upset about or frustrated about, because this is what typically happens in most cases. But you'll be able to look at those patents and publications, and then you can respond to the communication, which is referred to as an office action. Typically want to respond within 3 months to avoid extension of time fees, but you do have up to 6 months to respond if you do want to pay those fees and you need more time to evaluate it. But in that response, you want to make sure that you're addressing all of the references, and if you need to make any amendments or changes to the claims to address the references that the examiner has identified, then you can do so in that response. So I mentioned that here. You want it to be brief. You don't want to be talking just generally about your invention. You want to specifically respond to the rejections that the patent examiner has made. And if you are making changes to those claims, as we talked about before, they have to be supported by your specification or your written description, which could also include the drawings. We show those amendments as, it'd be currently amended or it's a canceled claim. And then there's generally, process to using underlining to show additions to the claims, and then strike throughs to show deletions, or brackets to show the deletions. And if you're working with a patent attorney or agent, they'll usually take care of those kinds of things for you. But it is important to know that there is a format that you need to follow on that to make sure that you're being in compliance with the Patent Office requirements. So hopefully, once you've gone through the examination process, you get a notice of allowance, and it will identify what claims have been allowed. It will confirm the amount of your issue fee, which should be in that range of $300 for the micro entity, $600 for a small entity. Although the fees are reassessed each year, so what we tell you today may not be the same next year, but all of those fees are posted on the Patent Office website, and they do specifically identify that amount when they do send the notice of allowance. They confirm when the issue fee must be paid, which is 3 months, within 3 months after the notice of allowance is mailed. And then sometimes the notice of allowance will also list reasons for allowance, which can give you some insight as to what the examiner thought was truly patentable about the invention. That's not a requirement for a notice of allowance, but it's something that we do see sometimes. But you do have to pay that issue fee by the 3-month deadline. You don't get extensions on that. Otherwise, the patent application will go abandoned. So you want to make sure that you've got that date calendared. If you are working with an attorney or agent, they should remind you about that and help you make sure that you meet that deadline. But you do want to make sure that you're doing that, because you can't extend that deadline out. So maintenance fees, I mentioned those before. Typically in the US, they're due at 3.5 years, 7.5 years, and 11.5 years after the grant date of the patent. So that was that date in the upper right-hand corner on the cover page of the patent. And you need to pay each of these fees at the, in the windows that are identified, or else the patent will expire or go abandoned. So they ask for these fees periodically because there are some some patents that may no longer be valuable to the inventor or to the owner of the patent after some period of time, maybe because the technology has gone obsolete, they've moved on to something else. Maybe they're no longer in the business anymore. And so, you can consider at each deadline whether you want to, keep the patent alive. It does become more challenging, if you don't go ahead and budget for these fees to be paid, because they do increase at each deadline. And so the last fees are actually quite large, relatively speaking. I think for a small entity at the 11.5 years, it could be over $3,000. So you definitely want to be aware of that. There are micro entity discounts, so that would reduce the fees somewhat, but they're still somewhat significant and more than what you've paid at the issue fee or at the filing fee stages. Those fees are paid online, and I recommend doing that because it's kind of an immediate payment, and so you don't have to wait for any processing, and the patent office confirms that it's been renewed, and so you can do that online, or you can have an attorney or agent do that online. This is kind of the one part where there are some owners of patents that just go through that process and do that themselves because it's not a protected part of the U.S. Patent Office website, and so anyone can go on there and if they've got their application number and their patent number, then they can find their maintenance fees and get them paid. But again, you have to pay those or else the patent's going to go abandoned. So finally, I just have a couple of pointers here. We've talked about a couple of these here, but I just wanted to reemphasize some of them and mention some as well. So the first one is I think a common myth that I hear is that want to make sure that we address is that just because you file a provisional patent application does not mean that you have a patent. Remember that it is a placeholder, and it's not giving you any rights. It's basically just preserving your filing date and giving you the ability to file the non-provisional or the formal application within a year to keep the process going. And that leads to the second point. You have to file that non-provisional application within 1 year to keep the filing date or the benefit of that provisional application. You can't go back and try to lay claim to it later on. There are some limited circumstances when that can happen, but not very often and not as a matter of right. So you want to make sure that you're doing that filing within 1 year. Third one is ensuring the sufficiency of your description. That's really important in terms of, making sure that you've described all of the parts of the invention in a way that somebody reading it that maybe is familiar with this field that your invention falls within, they can understand things that you're talking about and essentially understand how to make or do whatever invention you're trying to claim. That ties into the fourth point, which is the importance of your patent claims. You want to make sure that those at least cover your invention, that, if you're planning to sell a product that has your invention as part of it or is your invention, you want to make sure that your patent claims are at least covering what you're planning to sell or what you're selling. But ideally, you want them to be broad enough, within reason to make sure that as much as possible, you're covering what maybe your competitors might do or logical modifications that might be made to your product that could also be protected within the boundaries of the patent. So having an attorney or an agent working with you on that can really help, because you can provide, as the inventor, you can provide a lot of the technical information, and then the attorney or the agent can help you to finesse that into claims that hopefully have the right level of scope that can protect you, but also perhaps keep others from being able to do obvious modifications to what you're trying to protect. The fifth point is relevance and emphasis of prior art. I mentioned this in the background when we were talking about the background section, but ultimately, if you have done a search or you're aware of things that are out there, you want to be able to, you're required to provide that information to the patent examiner when you're making your submission, but you don't have to characterize it. You don't have to provide long explanations of, why your invention is the same or different, or, why you search these sorts of things. And so it does have, some importance, but you need to kind of keep that in check to make sure that you're not, characterizing it in a way that maybe is minimizing your invention more than you want. And then finally, the on-sale bar. Sometimes this is referred to as like public disclosure more generally, but I will cover it, is that there's, on sale is kind of one of the components of the statutory bars. And so in the US, we have requirements that if one of these following events have occurred more than 1 year before you file your patent application, then you can't go and later file a patent application. So one is, if you're aware of, of the invention being patented or described in a publication, anywhere in the world, then, then of course you can't go and file an application on something that's already been, described or patented by somebody else. You do have a grace period that if you've put it out in a publication, then you would have 1 year to then file a patent application on it. But typically, if you're going to have a printed publication, you want to try to file your patent application before it gets printed, so that it's not considered to be a public disclosure that could limit your rights in other countries, even though it may not limit your rights here in the US. If it's in public use, so it's something that people can see out in the US, then if that happens more than a year before you file your application, then you may be barred from filing. And then finally, if it's on sale, so you've offered it for sale or you're selling it in the US, then if that happens more than a year before the application is filed, that could also be a bar. So finally, I'll mention a couple of things. Sometimes we get questions about software patents, and I don't want to go into this in much detail, but I'm happy to answer any questions that people have about them. But there are a lot of questions that do come up related to software patents, because there are some Supreme Court cases that have been issued over time related to software that have made people think that it's very hard to actually get a patent as it relates to software. And while it can be more of an uphill battle than some other inventions might be, there is a patent eligibility requirement that you want to make sure that you're meeting when you are filing a patent application related to software. And so the kind of the key from this Alice versus CLS Bank case that I referred to on the slide here is that you need to emphasize how it's an invention that improves the computer technology itself. So there's an improvement on what's being done, and you're not just using just a basic computer to perform the functions, and nothing kind of new and different is happening out of that. There are some other areas that could be considered to be ineligible, patent subject matter, and this would be, really in the case of if you're just talking about a pure algorithm, just a mathematical formula, outside of the context of some, product or process that it's being utilized in. Hedging risk or financial instruments are typically considered to be ineligible. And then, naturally occurring phenomena such as like DNA or things like that can also be patent ineligible. So that's, there's a lot of details there. And particularly if you do have an invention that you're concerned about, whether there is, whether there is a possibility of getting patent protection, then I really encourage you to sit down with a patent attorney or an agent and kind of talk through that, because sometimes there are actual inventions that can be protected, but you may be focused on, the aspects that may be ineligible, but there could be other parts that, when taken together, it could make something more eligible for patent protection. You'd still have to meet the requirements of showing that it is eligible for patent protection and all, but at least at least you might have a shot there. So definitely worth sitting down with somebody and discussing it, but but definitely wanted to mention this to you because it is something that we're seeing more and more especially when it comes to computer related inventions. So as a final point on this before we open it up to to questions and can talk more about things is as Elisa said, we do work with the with TALA, which runs the patent pro bono program with respect to to Texas, and this is a pro bono program for patent for patent applicants. But to be able to receive the services, you have to meet certain financial requirements. So it's household income is below 300% of the federal poverty guidelines. There's also some requirements in terms of what you have to do before bringing your invention to us. We want you to at least have done some searching related to your invention. We do offer patent clinics that you can attend, and you can do that even if you have specific questions or but particularly if you do want to enter the TALA patent pro bono program, you need to either attend the patent clinic or have already filed a provisional application. You'll be reviewed by TALA to make sure that you're ready to file with the USPTO. There is a basic training course that the USPTO provides that you need to complete, and then there's an administrative fee of $100, and you would also be required to pay the filing fees, even though the attorney or agent's fees would not be your responsibility if you're working as part of TALA. So if you do have questions about that, Elisa would be able to answer that, or we can, we've given the contact information here on the last slide. If you do have specific questions about, about TALA or about the patent program, you can call the number. You can go to the website. All the contact information is there, or you can send an email and that can be addressed. And then, of course, if you need or want to contact me, my contact information's on here. I'm always happy to answer questions, point you in the right direction if that's helpful, and generally just try to make sure that everybody's on the right track when it comes to the patent filing and examination process, because I know it is sometimes a daunting process, particularly if you're doing it for the first time. You want to make it as as easy and understandable as possible.
There we go.
Great.
Hey, Kirby, can you see me now?
I can.
Yay. Thank you so much. That was so informative. Sue, just to follow up on that last slide, could you tell people how they could do a prior art search, or maybe give some hints of what they could do before they contacted TALA or maybe attended a clinic?
Yeah. So the way that I recommend doing it, and I think the one that probably most of us are most familiar with and comfortable with is using Google Patents. It's essentially like if you're using Google for your general searching on the internet. If you go to Google Patents, then you can do word searches of patents and patent applications on there, and it will give you lots of information. At least you can limit your results. You can add more words in. You could say, I only want to look at things that are relevant to the US. You can look at, foreign things, lots of different things like that. So that's definitely the best resource. There are some other resources you can certainly search using the Patent Office website. They have they have search tools on there. If you are in, for example, and I believe, Austin has it, but, Dallas as well. Lots of the, if you look on the USPTO website, they have several libraries, and then other institutions, around Texas and then around the country that have the computers that the patent examiners use, and there are librarians that are trained to help you to do those searches. I know now that some of the libraries are opening back up from pandemic. That's going to be something that perhaps is a little bit more available. If you are in Dallas, there is the USPTO regional patent office that is in downtown Dallas, and they have a searching room that they have somebody that is in normal times is available to help with that searching. And so that's a great resource, because they'll walk you through that. There are some other things such as I actually like Free Patents Online. That's a nice tool, easy one to use. A little bit. I think it's a little bit more user friendly than the Patent Office website for searching, but probably it's a little bit more specific, in terms of the I guess how you set up searches on there. But they walk you through a lot of that. And so I think it if you're gonna start somewhere, though, Google Patents is usually good because it's going to try to sort the results based on your relevance, the relevance to whatever terms you put in there, and so you can feel, you might be at least a little bit more comfortable with what's gonna come up than if you're just getting it, purely based on more of a formulaic search that you might do through the Patent Office.
So another question we get is, how long does this whole process usually take?
Yeah, so that is, I think I mentioned before, there's it's always hard to say for certain how long it's going to be, because there's because so much of it so when you think about when your patent application gets filed, patent applications are on lots of different technologies. So you have chemical and mechanical and electrical and design applications and things like that, and they all get assigned to different groups within the Patent Office based on the type of technology that they're that they concern. And so there are some groups that may have, I don't know, perhaps a little lighter workload, may not have as many inventions, filed in their area, and so they can get through their applications faster than perhaps say, some of the groups in the Patent Office that maybe are dealing with smartphone apps, that there may be many applications filed there, and while they may have more examiners that are working on it, they would still have kind of a backlog of applications. And so I usually say that probably unless you're accelerating it through paying extra fees, probably, thinking about, 18 months to 2 years is probably an average amount of time once you file the non-provisional. There are some areas where it may be even longer than that. The good part about that is, it never really seems good that it's taking longer, but particularly if it becomes the fault of the Patent Office that it's taking longer, and it's not because of anything that you did, to delay the process, then hopefully once your patent is allowed and is going to actually issue as a patent, then they will sometimes add days onto your patent term for all the delay that that was kind of beyond what they consider to be reasonable for a patent application. And so I've had situations where where an application may have been pending for 3+ years before it was examined, and then when we've gotten the patent issued, then we've gotten a year or more added on to the patent term because the Patent Office took longer than they expect to. So there can be some some benefit there, but certainly I would be prepared to wait at least that long. The other thing that you can do, and I recommend to a lot of people is one. I guess I didn't mention it during the presentation specifically, but applications typically publish, are available on the Patent Office website or through Google Patents or otherwise. Unless you've requested that it not be published, they're usually published 18 months after the filing date. And so once it's actually published, then then you're able to go in and do a search on the Patent Office website to check the status of your patent application. You can check it earlier if you've gotten that, if you've got an attorney or an agent that filed the application for you, or if you have the special filing code, or filing rights assigned to you, through the Patent Office website. But on there, you can do an action prediction letter where it will, give you an estimate based on which group it got assigned to, to figure out how long it might be. And it's just a rough estimate, but I'd say usually those are fairly accurate within a couple of months. So we typically do that for patent applications that we're working on, just to kind of get an idea of, where they are in the process, and, try to manage expectations, but also, prepare ourselves for when we might be seeing something that we need to address.
So can you address during that time of like 18 months to 3 years, is there certain things that the patent applicant should or shouldn't do in regard to the patent?
Sure. So that is a question that we get, we do get a lot, because there are sometimes when people think that they shouldn't be out there, selling or marketing or, doing anything related to the invention while the application is pending. And I'd say, in most situations, that's not really the case, because it's, you're able to say it's patent pending, while while you're out there marketing it or selling it. And so I think, you don't really have to put everything on hold while you're, while your patent application is pending. It's also something, particularly if you continue to develop, develop things related to it, you may have follow-on applications that, may cover other features. And so, and if you do have things that are related to your original application, you can file those in what's referred to as a, continuation in part application that may, would give you the original filing date that you had for your original application that you filed, and then you would just get a later filing date for anything new. And so, so sometimes people are using that time to kind of further develop or refine the invention, or, or depending on the type of field you're in, they can also be doing testing. If you're not at the point of selling or marketing it, and especially when it comes to chemical or pharmaceutical type things, there's sometimes a lot of testing, either consumer testing, lab testing, those kinds of things that can be taking place while you're while you're in that pending time. That might actually be helpful to you if especially if you do some of that testing, even though it's not part of your original patent application, you could actually use some of that testing to further show the importance of your invention. Because if you've gotten feedback from customers, or you've tested the efficiency of the product or something like that, you may be able to present that to the examiner as further evidence later on.
Great. We had a question come up about, can you use pictures instead of drawings?
Yeah. So pictures. I think and I'm not. You can certainly clarify this for me if I'm not understanding it right. But yeah, pictures can definitely be utilized. I mean, I've had cases where where we've used photographs. We've done sometimes like when we roughly refer to it as drawings, it's kind of sometimes it can be block diagrams, sometimes it could be sketches, sometimes it can be it could be a photo, it could be a lot of different things. So as long as you're meeting those requirements, then there's they have a lot of flexibility with it. Okay.
And then we were asked if you could just review the current fee ranges.
Sure. Yeah. So there's like I said, there's a lot of different fees that you have, and I assume most of the time people want to think the most about the original filing fees if you're actually doing a non-provisional filing application. And so those are the filing fee, the search fee, and the examination fee. And unfortunately, you have to pay all three of those at the time of filing, but they're meant to cover kind of the different parts of the patent process that the patent office will be dealing with. And so when it comes to a micro entity, so if you do qualify as a micro entity because of the gross income requirements, then that filing fee, the filing fee is $80. The search fee is currently $175, and the examination fee is $200. So you are looking at $455 that you'll need to be able to provide if you qualify as a micro entity when you do the filing. If you are doing if you're just a small entity, so you maybe don't qualify based on the gross income basis, then the current filing, search, and examination fee combined, it's $830. So that's what you're going to pay, to kind of get the process started. And if you were working with TALA, then you would, I'd say I can't say across the board, but based on the income requirements and things that TALA kind of requires, for entering the program, most people would probably qualify under the micro entity. So you'd be looking at that lowest amount for those initial filing fees, and then your next fee that you would be looking at is the issue fee, which for a micro entity is $300, and then for a small entity, it's currently $600.
Great. I've got one more.
Okay.
So I want you to comment on the standards of evidence for scientific provisional patents.
Yeah. So this is good. So there's So when we talk about a provisional, kind of the lowest level requirement is that you're including enough information in there so that somebody that is essentially in the field, has similar, usually say, kind of has similar qualifications to you. So, so it wouldn't be somebody that is, if you're operating at a undergraduate degree and have, you don't have extraordinary, extraordinary capabilities in this area, you wouldn't be expecting that it, you're having to write it at the level of like a PhD, vice versa. If it is PhD level, science, then you could be writing at the level for other PhDs, if that's what would generally be required to understand the field. And so that's kind of the base requirement. And so there's not really specifics in terms of, how much information you have to have in there. And I think, particularly if it's, but in the case of, let's say, in case of a chemical or pharmaceutical invention, you want to be able to, to show that, show enough, information that would support that the invention will do what, so if it's a methodology for doing something, or you've come up with a new composition, you want to make sure that it's, that what you've described in there is sufficient to show somebody that it is possible and that you've come up with that. And so some of those things, though, when it comes to like for the different testing methods or things like that, you may be able to do the provisional based on, hey, I think I've come up with this composition. It has, we make it by this method. It seems to have these properties, but maybe you haven't done all of that testing yet to completely prove it out, but you know what you're going to do, and that's going to further, hopefully further validate the invention. Then those are things that sometimes you can do between, filing the provisional and filing the non-provisional. So there's so sometimes it's, I know I mentioned a lot of different reasons why somebody might use a provisional, but one of them is, is that, you've got the good base invention, enough described that, that you've, somebody could read it and understand what it is that you're trying to, you're trying to convey and why it's important, but you just need more time to be able to run some of those tests and further further validate it, maybe, you know, come up with some of the other alternatives of how it might be used or how it might be made. And so you're not necessarily required to have all of those things in there for it to qualify for its, you know, provisional filing date. You can do some of those things between the time that you file the provisional and the time that you file the non-provisional.
Thanks. So I had a question too about, say you're not eligible for TALA and you just don't have the resources at this point to pay someone to do it for you.
Yes.
I know that the USPTO has some pro se help that they give people. Could you comment on the possibility of doing this on your own and whether you should consider that or not?
Yeah. So I'd say that it's I mean, I would say, you know, clearly if you can work with somebody, you know, whether it's through TALA or I'll also mention there, you know, with, you know, here in Texas, we are lucky and, you know, have this in other states as well. But, you know, we do have, you know, several of the law schools around here in Texas do have patent clinics that, you know, while they do have some requirements, you know, related to, you know, income and the like, I think they're a little bit more, they may have a little bit more flexibility than we do in terms of, you know, the resources that they have. So that's another option. But, you know, if you do need to, you know, if you feel like, you know, you don't qualify or, you know, you can't, but you also can't go and hire somebody or feel like you can't hire somebody. If you were going to do it, I would probably, I mean, one option is to, you know, like I said, the provisional has less requirements and they can kind of walk you through that process a little bit easier. So sometimes people will go and do a provisional on their own first and then try to come to, you know, maybe it's a matter of, you know, kind of allocating the money or, you know, maybe getting some funding or, you know, doing some things, you know, over the course of that year that the provisional is pending to, you know, to try to get some help for when they have to actually put the claims together and those kinds of things. But if you do need to do all of that on your own, you know, I would really utilize, you know, definitely recommend, you know, diving into the independent inventor and other like pro se resources that the USPTO website has. They do have, I mean, even as part of the TALA program, as I mentioned, we do have everybody, you know, do that, you know, certification course that the patent office patent office has on its website. And I think that gives a lot of good information for how you walk through the process. And if you do have specific questions, you know, particularly if you're getting into the filing of the application, then they do have a phone number where they will provide some level of support on, you know, answering questions, you know, particularly if it's technical questions about how you actually complete the filing or, you know, if there's a particular form that you need for something. Unfortunately, on the patent side, I would say it's their resources are not as user-friendly as perhaps they are on the trademark side of things. But I think that's also just because, you know, more people tend to independently, you know, file trademarks, and there's not a specific requirement, you know, for you to be registered to practice in front of the trademark office as there is, you know, for attorneys or agents to practice in front of the patent office. So I think that's probably some of the difference there, and it can be a little bit more complicated. And so I think they try to encourage, you know, utilizing an agent or an attorney as much as possible. But there definitely are resources there, and I would certainly start there as opposed to I'll kind of, you know, put in my my warning for, you know, for people, you know, trying to utilize you know, these online services that you know, purport to help you with your patent filings, and then they say, you know, I'm sure you've seen them on television, you know, we'll market your invention, we'll get you a patent, we'll do all those things. I've had a lot of clients and others that have had not the best experiences through those, and I think you'll find that, you know, even though you may may think you're saving some money on the front end for, for utilizing one of those services as opposed to, paying an attorney or an agent to do the filing for you. Sometimes you end up having to pay that money somewhere down the road because you may not get everything that you bargained for. So I try to steer people away from that as much as possible. And if you do have to do it yourself, I would just try to rely on the resources that the Patent Office provides as opposed to trying to utilize those services if you can.
Some great advice. So I think that's the end of our presentation.
Okay.
Again, TALA has a patent pro bono program that we could help you and walk you through this process if you financially qualify and you do have an invention that's basically ready to go in the system as a non-provisional patent. So the process has been, if you already have a provisional and you're ready to do the non-provisional, you can enter our program directly. If you do not have a provisional, we have been offering clinics, and it will allow you 30 minutes to talk with an experienced patent attorney like Kirby and just kind of talk through your invention and see if it is ready to go or if it needs some more work, or just to get advice on your actual individual invention. I believe our next one is going to be in June. We just had one recently. If you go to our website, there's a place you can sign up to get on the list, and then we will notify you of the next date when that is scheduled. And then you can sign up for a slot to talk to a patent attorney. And we just started those recently, so I'm not sure how often that they're going to be, but I'm looking that we'll probably have one of those at least every couple of months. So do get on that list, and then hopefully when the next afternoon, evening comes up, we do those, that you can join us to discuss your actual invention. Any parting words, Kirby, for inventors tonight?
No, nothing more than just, kind of definitely, pay attention to the rules, and certainly, if you have the time and the ability to join the clinic sometime, particularly if you do have, specific questions, it's a really great opportunity to hear some of this information again, but also, to talk with somebody one-on-one about, specifics that you might have concern about with respect to either an invention that you've already got working or something that you're contemplating doing. So, definitely utilize that. And then, if you do have questions about the process, about, resources, things like that, I'm happy to answer those. And if you have questions about TALA, then please go to the TALA website, and it has lots of resources there, or you can contact them directly.
Sounds great. Well, thank you so much, and thank you for your service to our organization and to Texas inventors. Your help on this program has just been instrumental to helping countless numbers of inventors in Texas that would not probably have been able to move forward at least as quickly and efficiently as they have. So from the bottom of our heart at TALA and our board and our staff, thank you for your contribution to us and to inventors. And I think that's going to be it for tonight. So we hope that if you joined us all the way through, that we will see you again at another event or possibly joining our program. So good night.